Which is better to protect your kids and family in the event of a death, a will or a trust? Is there a difference between them? Today, I will explain those differences and why you might need both. I'm Jennifer Nichols, owner of J. Nichols Law, and I help people in Texas protect their assets so they can pass according to their wishes. Planning for what happens after you pass is a tough conversation, but it's essential. Part of caring for your loved ones is making sure the right plans are in place for when you are gone. When this isn't planned correctly, the result can be costly and time-consuming. One of the first decisions you need to make is how to protect your assets. So, where do you start? Let's start with what a will is and why it is important. One part of Texas estate planning that most people don't know is that if you don't have a will in place, the state of Texas will decide how your assets pass. After working a lifetime to build your assets, do you want the state of Texas to decide who they pass to after you're gone? A well-crafted will ensures that your assets are distributed according to your wishes. It helps avoid family conflicts, costly disputes, and ensures your family receives what you intended. A will also allows you to appoint an executor to manage your estate, appoint guardians to take care of your children, and to make specific requests to individuals or charities. Wills can also incorporate trusts in them to leave assets to beneficiaries in trust instead of outright. However, a simple will alone may not be enough to protect your estate fully. This is where having a trust comes in. A simple will alone, that's a will without trusts, is often insufficient in today's complicated legal and financial landscape. If you want to preserve your assets for your loved ones, you may need a trust. However, there are many different types of trusts available covering different situations. Trusts are either testamentary trusts that are created in your will to take effect after you die, or they're Irrevocable trusts, which are standalone trusts created during life. The first type of trust I want to talk about is the Contingent Testamentary Trust. I recommend setting up a contingent trust in your will for beneficiaries under age 25, though you can select whatever age you feel is appropriate. This type of trust doesn't come into play unless the beneficiary is under the designated age, say 25, such that if the beneficiary is 25 or older, they receive their benefit outright. But if they are under age 25, their inheritance passes in trust for their benefit. The trustee of the trust, usually a family member, can use the assets in the trust for the beneficiary's benefit until they reach the designated age, at which time the trust terminates and they receive the assets outright. Another trust that I recommend spouses consider, especially blended families, is a spousal testamentary trust. This trust is also set up in your will and comes into play after you are deceased. It provides that upon the death of the first spouse, their share of the estate passes in trust, with the primary beneficiary of the trust being the surviving spouse and the remainder beneficiaries being the children. The spouse is allowed to access the trust during life as needed, but upon their death, the remaining trust assets pass to the first spouse's children. The spousal trust can be in the form of a bypass trust, with or without a marital trust, funding the bypass trust with an amount equal to the estate tax lifetime exemption amount. This trust can reduce or eliminate estate taxes for an otherwise taxable estate. Another type of trust is a special needs trust. Special needs trusts allow a person with disabilities to have financial support from their trust without jeopardizing their eligibility for governmental benefits, such as Medicaid and supplemental security income. They can be formed in your will or as a standalone third-party trust. Retirement benefits trusts are inter vivos standalone trusts that can be used for spouses or for children. A conduit retirement benefits trust for your spouse allows retirement benefits to be paid out over your spouse's lifetime. Upon the death of your spouse, the remaining benefits will pass to the beneficiaries you name in your trust. An accumulation retirement benefits trust for minors allows the trustee to either distribute or accumulate retirement distributions within the trust. This structure avoids the need for a court-appointed guardian for minors receiving retirement benefits. This also prevents young beneficiaries from squandering inherited assets. Irrevocable life insurance trusts are trusts that keep life insurance proceeds out of your taxable estate. They allow the death benefit to pass to beneficiaries free of estate taxes. They also provide asset protection from creditors and allow the grantor to specify how and when proceeds are distributed. These are just a few of the many different trusts that are available. Combining a well-drafted will with a properly structured trust ensures your estate is preserved and your assets pass to who you want them to pass to. If you or someone you know wants to protect their assets, please schedule a consultation with J. Nichols Law. We'll explore all of your options to ensure your legacy is protected. Thanks for watching. If you enjoyed this video, please like and subscribe and turn on your notifications for more videos like this. See you in the next one.